today from the Wangan People's Territory, which comprises the Esquimalt and Songhees Nation, and also grateful to be adjacent and a part of Sinchothan with Saanich territories as well, as feel grateful to be able to work and live and play in these territories. I welcome you to this National Next conversation and thinking about the vitalization of Indigenous law through teaching and interacting with one another in ways that are exciting to be a part of. We've got some distinguished guests that will be a part of our time together here today, and I'll introduce them in a few moments. But first, I want to express my appreciation to Dr. Skip Dick for being with us. He's a good friend of the university, and I've always feel grateful to hear his words and see him in various places that we gather together. And I'd like to turn the time over to Dr. Skip Dick to say a few words and welcome.
Good day. Hello, my friends, HYL, and my dear friends, relatives. I want to, first of all, express my gratitude for the university for allowing this to happen. It makes me happy because it's one way to honor the old people by carrying out our old ways and also making sure that the protection of our community is there. And then most of all is that our esteemed leaders who are coming to our land, I want to make sure that you're comfortable and happy. And most of all, the old people would make sure that along with the welcoming to the territory, it's just one of our ways to make sure that you have a wonderful day in all your deliberations. And I want to say welcome to our territory. Aichka. Thank you.
Aichka Siam Skip, it's wonderful to have your encouragement and feel that power that you bring whenever you're a part of our work. So Aichka, thank you so much for being with us. As I've mentioned, this is a national
recording in progress
conversation, and we're excited to see this as a kickoff for 4 conversations about education, revitalization, the practice of Indigenous laws within the broader academic and legal community, as well as always having that focus on Indigenous communities as where those laws are from and who those law keepers are and ways that we can support and aid and assist and interact with them. We want everyone to be a part of this conversation today with myself and Naomi and Darcy and Jeff, who will be joining us later. But before I introduce them, I just want to give a few housekeeping points here. Throughout the event, we invite you to share your reflections in the question and answer box that's below. We'll be monitoring that, and we'll be able to go to that specifically from time to time in our opportunities to be with one another. And so please get engaged with us after that fashion. And then, of course, since these are next conversations, for many of us, we've been in conversation for quite some time. And those that are joining us for the first time, we hope that you'll see this as one of many occasions to be able to gather and participate with us and help us understand the work that's in front of us and around us. I wanted to just start by mentioning that today I was, actually last night I dreamt about bears. And I wondered what that had to do with this day. And then I realized back in my territory, this is Makakonsagizis, which is the bear cub moon. And so as we're gathered together, there is life gestating below the earth as these little ones come out and they start to be nurtured by their mothers in that space. It's a beautiful time of thinking about protection and growth and understanding of the necessity of having those spaces that are protected from the winds and the cold and the rain and the sleet, and to see that things can start to come to life even if we don't see them. And during this moon back in Ontario, when this occurs, you get this mist that starts to rise over the land as of course the sun interacts with the snow and it starts to melt a bit. It blocks our vision a little bit because of those mists. But when we see that during this month, Makakonsegisis, we actually recognize that as the afterbirth that comes out of these mothers who are bringing these beautiful cubs into the world. And it's really interesting. Our word for box is makak, and the name for a bear cub is makakons, right? So these little ones are boxed up there inside the earth at this period of time. And I make this point just to illustrate the fact that there's so much that's happening around us that we might not see, that is exciting, that is revitalizing, that's bringing forward a future that allows for that cycle of life to be repeated. I also make this point to indicate that there's a literacy involved in understanding the earth and the forces around us that we can pay attention to and learn from and take guidance from, and see that as standards and principles for making our own judgments and arriving at the way we will put our own affairs together. In other words, the land itself is a source of the law. That's our legal archive. Our professors are the little bears and the mother bear, and they're able to share and provide information to us about how we can undertake the journeys that we're on, to live in harmony, to live with respect, to live with order, to learn how to disagree with one another in agreeable ways. These are the sorts of things that are so powerful about thinking through Indigenous law. And we've really got a treat here today to have some guests with us who are going to be leading us through some of this discussion. We have Naomi Metallic, who is joining us from Mi'kmaq territory. She's from the Listugush, a Mi'kmaq First Nation, and is an assistant professor at the Schulich School of Law at Dalhousie University. And she holds the Chancellor's Chair in Aboriginal Law and Policy. Then we also have Darcy Lindberg with us, who's an assistant professor with the University of Alberta's Faculty of Law, where he teaches courses in constitutional law, Indigenous legal traditions, and Indigenous environmental legal orders. He's a mixed root Plains Cree person, and he joins us today from Treaty 3 territory. And then our final guest, who will be coming with us in the second half of our time together, he's actually teaching right now, is Jeffrey Hewitt. Jeffrey Hewitt is mixed Cree descent, and he's an assistant professor at Osgoode Hall Law School, where he teaches constitutional law and Indigenous related conversations and ceremonies. I want to welcome Naomi and Darcy and look forward to having Jeff join us in time, and just get right into this with a conversation with you about these issues of learning and teaching Indigenous law within the settings we find ourselves. And I think I'll just kick off a question, throwing it over to both of you, and you can decide who wants to pick that first. Can you describe to me what it feels like to be an Indigenous legal educator? And as you think through that and describe that to us, maybe reflect on some of the challenges that are part of that role, some of the joys that are a part of what you experience. Maybe I'll turn to Naomi first, just to give us some thoughts on that.
Great, I'd love to. Well, Dasi Begisin Giskok, I am very happy to be with you all today. Yeah, so in answering this question, first I should thank John and the organizers for inviting me. I am really honored to be a part of this discussion. And I'll start by answering the question, explaining a little bit about my background. I graduated law school in 2005, and Indigenous law was really not focused on when I went to law school. And after law school, I practiced for about a decade or so. And although I was privileged to be able to work with First Nations communities in Mi'kma'ki, as well as other parts of the country, the focus was primarily around Aboriginal law, so Canadian law as it relates to Indigenous peoples. And so I didn't have a lot of exposure. So in some respects, I'll give a little caveat that in some respects, I'm being on this panel, I feel like a little bit of an imposter. I don't feel that I'm an expert yet in Indigenous law. I still feel I am very much a student. But I'm still happy to talk about the work that we've been doing. Since I've been at my law school for about 5 years now, we've been doing a lot of work to try and push knowledge about both Aboriginal law and Indigenous law. We've added several courses in trying to do that, some of them mandatory, some of them optional. But when I did get to the law school and really started to learn about the great work that John and others like Val Napoleon and Hadley Friedland and my colleagues on this panel have been doing, I decided I was going to push myself, and I didn't really know much about the area, but I was going to push myself and learn about it and teach it. And so the first time, so I didn't develop, Hadley Friedland kindly shared with me much of her material and wisdom and guidance in the method course that she teaches at the University of Alberta. I taught it for the first time last year, and so I've taught it twice now. And I really must say, when I first started teaching it, I approached it with a lot of fear. I guess some of it being, the ideas of, well, how can I teach this? I'm not a fluent speaker. For the last 20 years, I've lived in the city. I haven't lived in my, home reserve community for about 20 plus years. But as you get into the materials, you quickly learn that's sort of essentialist thinking about who it is and who should be working with Indigenous laws. And you learn very quickly that we need to work past that and get past that. And I found that the students in my class, I had 16 students, they, didn't know what they were getting into either, but they were equally eager to learn and get their hands into this. So it was exciting. It was certainly less scary to teach it the second time. But I have to say it's the work, I think, is probably some of the most exciting and soul nourishing work that I can do. I have to do it with other work. I guess that's the challenge, and I'll talk to that in a second. But growing up, my father was a historian and a Mi'kmaq linguist, and but didn't really have a lot of chance to engage with his work in the last several years of my practice. But actually, in doing the work around Indigenous law, I'm able to reconnect with his work around language. And so what John was talking about at the beginning about breaking down the words for baby bear, I mean, I love that. And there's so much work that can be done with our language in that regard. And I've been learning my language for the last couple of years now, but also working with our stories. There's just something that I think, as much as I loved my practice, I always felt that there was something missing. And I think a lot of my clients felt that too. And I really feel that working with Indigenous law is that piece that felt that that was missing. I probably can elaborate more on that after, but in terms of challenges, I've institutionally, my colleagues have been extremely supportive, so I felt lucky. I think the challenges are just resources and time that I, want to do more, and I want to spend more time on this. I'd probably like to spend all my time on this, but I also have, other things that I have to balance with that. And I would love to build on, what I think right now is, one course. I would like to see that expand, but there needs to be, I think, more people at my institution that I can work with on this, and I think that's coming. So it's more of the the resources and time issue. And I guess another challenge is just I really want to start, training other alumni who are Indigenous, in particular in this. so they can start working with communities and having more access to communities. So it's just the desire to do more and just realizing that we're still at the start. But this is an exciting conversation to be having, to be talking about how can we do more together. So thank you, John.
Thank you, Naomi. It's really key to hear your feelings about this because I think it's something that is shared pretty widely. When you approach Indigenous law, there's this feeling of caution and humility and knowing that you know so little in the face of all that there is, really produces a lot of self-reflection. And with that self-reflection comes doubt, but it also comes with inquiry and reaching out and trying to seek guidance and find places where you can get what you might need to help the folks that are there in your practice or in your classroom or in communities as they come and speak with you. We have 7 grandmother and grandfather teachings as Anishinaabe people, and they're sometimes worked into our written constitutions as well. And we have a word for humility, which is Daba Dane Dizuin. And that can be a measure of your thoughts, or it can be lowering of your thoughts, depending on how you pick up Daba, which is this measurement. Ain Dam is the things in your mind. And then Isa is the kind of the habitual way in relationship to. And I was taught about this concept, which is that we need to take up the right amount of space when we think about measuring our thoughts, because to completely resile from it when there's a need might not itself be humble, because we'll be thinking about ourselves. What can I do? What can I bring to this? Rather than thinking about the community or the students or what might need to be done in this area. So it's true to be, proud and overly sort of beyond is to take up too much space. And we certainly don't want to do that by any stretch of the imagination. That would be very self-centered to do that, right? At the same time, not picking up the right amount of space and just being like a mouse in the corner that never shows itself is ironically also not very humble. If it is the case that there's a need and there's possibility for engaging there. And I love those constitutional teachings that we have as Indigenous peoples, because they give us some guidance about how to go about doing the work. And when you put them beside the other teachings, right, it's not just about humility, but it's also about love and truth and wisdom and honesty and respect. You start to get a sense of how these things can correlate with one another, because those feelings are powerful, feelings of being unworthy, unable, not sort of qualified. I think that's a pretty widespread thing. And of course, we need to take caution with that, because we might not be qualified in some areas, and we might not be able in some areas, and we might not be invited or should engage ourselves in some of those places. Taking all that into account and recognizing when you shouldn't do something is a part of this, but there's also a place to take action in the world. Tradition can be the dead faith of living people or the living faith of dead people. And I often wonder, are my traditions kind of the dead faith of me who's living, or actually are they the living faith of those that came before me? And so they're the living faith of dead people. And I'd love it to see those possibilities for growth, recognizing there's always, always more than we can do and know, which is why we need to be together, counseling with one another and taking account of different perspectives, because no one person or institution can do it alone. Darcy, your feelings about this question of being a legal educator with these fields and some of the joys and some of the challenges.
Yeah, thank you, John. And thank you, Naomi, for your thoughts there as well. I just want to extend my gratefulness for being a part of this. Tansei Natodamak out there as well in the virtual world there. Hello, my friends. And I just really appreciate these conversations. I feel like somebody who just gets called off the bench on a sports team. I know people don't like sports metaphors in these. So I'm always excited to jump in there and to be eager to share my thoughts. And I was going to talk about this bear dream I had last night, but John's already done so. So I'm going to have to put that on hold.
You were bear last night?
I'm just trying to find a way to tease you, John. Actually, I will talk about a dream a little bit later here, but I always try to find a way to try to tease John to throw him off his game, but I haven't found a way yet. So I'll keep on working at that.
Speaking of teasing, I noticed the bear in Naomi's background. Just watch that next time she comes on screen.
Yeah, okay. So I really appreciated this conversation and hearing Naomi talk about her joys and challenges of this work. And the one, I mean, I kind of want to pull it back to, like, I was thinking about this as you asked the question, John, and as Naomi was talking. I think, like, one of my greatest joys from this work is really just this being engaged in collective learning. And so I know that's kind of disassociating it a little bit from the topic of Indigenous laws. But the way I connect that there is, like, I really just love people's experiences. And so it kind of ties into that, you put it aptly, Naomi, that feeling of being an imposter in these situations. I've found a way to ride that experience, so to speak, by thinking about, like, how are we collectively learning in this moment? Because the reality is even if I'm instructing something and I'm teaching it from a specific legal tradition, often Cree, that people are coming in with their own experiences. And so for Indigenous learners in those spaces, I just find them, like, I feel guilty often that I get paid at the end of the day sometimes, because it's just hearing what we often talk about is, like, oral traditions. I just love hearing people's stories, where they're coming from, these reflections when we start to think about, which I know we'll talk about methods and even philosophies of law in this conversation, just to see how those attach, people take those up and they start to think about their own communities, their family, their nations in those laws. So that's really, quite honestly, like, a really selfish wealth of this work that I find that I really carry with me after each class as well. So there's another part of that as well, is that's not only for Indigenous learners, but there's non-Indigenous learners as well. I teach a course, John talked about the course that I'm teaching on Indigenous ecological governance and legal orders, kind of a long name for it, but also a course on treaties and Indigenous people. And in there, with non-Indigenous learners coming in and able to situate themselves in that treaties is kind of a way to form a relationship, I guess, with our own histories together. I find that there's a lot of that sort of, like, learning about not only familial positioning, but also our legal orders with each other that occurs there. And so that learning as well, I just find it really gratifying with non-Indigenous learners as we work through our collective sort of stories together and how they braid together. So I know I'll probably talk a little bit more about that when we get into some of these further questions. And then the challenges is thinking about this, and a way to broadly think about it is just the idea of changing tides. And often when we're working within our institutions, Indigenous legal orders, pedagogies, Naomi mentioned the resourcing of it, it often will go against this tradition of a tide there. And so sometimes, and often, we're kind of pushing, we're countering that tide. And so I think that's where a lot of the challenges come out. So I like to think about this not just as content. I know I think that's the first thing we start to think about in our institutions is how we're adopting this content, but also how is it going to be sustained, how we are bringing more people into this conversation besides, I think, John, you had mentioned there's 21 legal scholars who are doing Indigenous or Indigenous laws out of 700 plus in law faculties across the country. And in a previous meeting, you mentioned that. So how are we braiding all this together, I think, is a challenge, because we do feel it when we're instructing. There might be something that comes up where it feels like situational conflict, but when we start to root it out, we can see it's often rooted into, trying to redirect a student's learning in a certain way, or something that, we have a learning that can go to a certain part, and it may not be quite sustainable yet for the organizations we're working with. So those are kind of like my challenges that I want to keep in mind as we move forward in this conversation. So I'm gonna stop there.
That's great. So you're both identifying similar things in terms of the challenges of resources and fit and expectations of yourself and others to do this work. And those challenges are real, but they're also there at the same time as you are expressing joy and enthusiasm and trying to bring about the possibilities that are present in the way you feel about things. And I think that's just really key to acknowledge, that we don't do our work just from our heads. We also connect that with our hearts, and trying to work that space together is really, I think, a key dimension of being balanced in our roles. There's a question that was posed, and I think it's just worth posing to the both of you, to kind of just step back a bit and think about what is Indigenous law, and how is that distinguishable from perhaps Aboriginal law? Naomi mentioned these categories of Aboriginal law and Indigenous law. And maybe, Naomi, if you could just tell us what you mean by that distinction, and we can pick that up with further conversation.
Sure. The distinction that I try to make, and that I teach my students, is that I see Aboriginal law as Canadian law as it relates to Indigenous peoples. So this can include, Section 35 of the Constitution Act potentially, but also, the Gladue provisions in the Criminal Code 718.2. In fact, I have presented several times explaining to people that, in fact, almost every area of Canadian law impacts upon Indigenous people, either substantively or procedurally, sometimes in a different way. And therefore, it's important to learn. But then I also explain that Indigenous law are the laws of Indigenous people. So the different nations that exist in this place we call Canada, and for me, I'll say Mi'kmaq, but Mi'kmaq laws. And so, that tends to be my understanding of the distinction. Perhaps I'll turn it over to Darcy if he wants to add to that.
That would be great. So on the one hand, we've got laws that Indigenous peoples engage with the Canadian state on, like those constitutional and legislative provisions, which is kind of that Aboriginal law or law Indigenous peoples get involved with that is state focused and involved. But then Indigenous law is the law that Indigenous peoples generate that could relate to the state, but comes from a different source. It comes from their traditions, their deliberations, their environmental interactions, their declarations, their customs. And that way of thinking about law is, it could relate to the state, but it has a different source of genesis, a different place from which it emanates. Darcy, what's your take on this question?
Yeah, I obviously couldn't put anything better than both of you are putting it. And the one thing I also use when I try to describe this to students is there's this great quote I saw on social media about just the term Indigenous. And it was thinking about that as like an analytic. It's a way to grasp something, to collectivize it, I guess. And so I often describe Indigenous law as that as well, because we know that obviously we're going to talk about different legal ordering, like Nehiyaw, Anishinaabe, Métis, etc. The list goes on in terms of like specific Indigenous nations with their legal ordering. And so it's a way for us to think about this collectivity and this area where we're thinking about that. I often correlate it when we think about environmental law as well in Canadian law schools, where you can think about laws that have that sort of dimension of environmentalism that come from a lot of other disciplines as well. So a kind of a rough sort of reference there. I know it doesn't always fit, but just to think about when we say Indigenous law, it's not this homogenous group, obviously, of laws and that are the same across the country, but it's a way to start to enter into that conversation about specific legal orderings, talk about commonalities, et cetera, to work through those. Yeah.
So we might more accurately talk about Anishinaabe law, Blackfoot, Nehiyaw law, Salish law, Inuit, Métis, etc. So that's a really important clarification, that the label of Indigenous can hide as much as it reveals. I've also liked this approach as well. You know, sometimes we think that law is only institutionally generated and understood through parliaments and legislatures, that if there's a dispute about that, might go to a court to interpret what the parliament and legislature said. Judge can give that interpretation with the help of lawyers. Perhaps we've got police officers or the executive branch of the state that participates in trying to determine what the parliament and the legislatures mean, and that's definitely law, and I don't want to exclude that from our thinking. But I also realize that law can be approached more functionally. What is the function of law? What does it accomplish? What does it do in the world? How does it do that in the world? And if we think in this frame, then we see law as standards, principles, criteria, measures, signposts, guideposts, precedent, tradition, authority, patterns of behavior for making decisions, regulating our affairs, and resolving our disputes. And if we think of law functionally, then it doesn't get in our way if we don't see a parliament somewhere or a court somewhere or a police officer somewhere. We can still identify law without those other institutional dimensions being present. And I think that's a powerful insight, because then it means that law can flow from societies like Indigenous societies that didn't historically have legislatures, perhaps, or courts, perhaps, or judges or lawyers. Although we can have those things, and we can make our legal systems have some of those dimensions to them, but they're not exclusively, and they're certainly not historically in that frame. And so if we think of law functionally, then we can see where we ourselves might get involved with communities, right? And say, what are your standards or hope for standards, principles, processes, criterias, measures, signposts, guideposts? That is, how can we do this together? Seeing law as a verb, in Akunage, Anishinaabe people say, as opposed to a noun. That is, law is something we conjugate as opposed to categorize. And if we think about the conjugation of law, or the verbing, or the constituting of ourselves, then that means there's really role for participation there. We don't have to wait for it to be done to us, a legislature or a parliament or a court coming along. It's something that we can pick up and act on, and find those spaces for being practitioners, and recognizing that practitioners aren't just law professors then. They're aunties and uncles and elders and our kids and the animals and the plants, because we see in that coordinating and that correlating function that there's a diffuse dimension to law that can take hold. And then the challenge is to identify what those components are in that diffuse structure, and then try to coordinate them, or point out what the coordination is for those who don't necessarily understand what's going on as law in that instance. Naomi, I'm not sure if you have reflections about that, and thinking about how you support your students, how you support those you're working with to name, understand, learn law. So yeah, just taking off from there.
Thanks. So I started, as I explained, with doing the methods course, and which I believe yourself and Val Napoleon, as well as Hadley Friedland, all had a part in. And so I'm sort of running with that, but that's an excellent course, I think, and really fundamental to get students to start thinking exactly in the way that you were describing, John, about law being about something more than hierarchies of power, a centralized state, decreeing rules, and seeing rules as these sort of immovable, frozen things. I know in law, I teach constitutional law, and I'm very much about living tree, but I do get the sense, at least at my law school, that sometimes students really do think about law just in that sense. I think they have a bit of a notion that it's grayer than your average citizen, perhaps, but still very much in that. Like, one of the things we do in the method course, I think early on, is get them to draw what they think law is, and then draw what they think Indigenous law is. And you do get these pictures of police officers and the scales of justice and a courthouse. And a good part of the first aspect of the methods course is thinking about law in that broader sense, about it being how beings living among each other resolve their disputes. And many of the students have said that their whole time in law school, they were never really challenged to think in that broader sense, and really took a much a really different view of the role of law, their role, the role of themselves as citizens and other citizens, in engaging in laws and rulemaking, or principle making, let's say, instead. So students have really responded to that in my classes. So I think the only thing I'll add to that, because I just wanted to touch on the point that Darcy made earlier about the joys, and I was talking a lot about the own joys that I took from learning this, but I also take an immense amount of joy of working with the students who are taking my courses, both Indigenous and non. But I really do have to say that I feel with a lot of our Indigenous learners, we've got quite a few at who go to Dalhousie, that you really see that it's so meaningful to them as well. And so I just wanted to add that to my joy list, because seeing students take a lot out of, and actually being very proud of who they are, I think is a big joy that I take from it too. So thanks.
I mean, really, it does make our job just worthwhile. Without the students, obviously we'd be nothing, and it just does give us so much encouragement and challenge as we work through that food for thought. Darcy, how do you help encourage your students to understand what law is? And we got a question along the way here. How might they know what law is in a particular situation or case, given that it's diffuse, it's held by different people? So how do you create a sort of a transparency, accountability, a sense of understanding what the intelligibility of that law might be in a particular instance or case? So the general question is, how do you encourage your students to understand what law is from an Indigenous legal perspective? But then the follow-up question is, once you sort of orient them to what Indigenous law is, how do you help them appreciate that it does give answers to questions? It's not just a kind of free-floating free-for-all, but it does have the ability to generate particular guidance and particular consequences as we move along.
Yeah, that's such a wonderful question. And how I think about this. So your question, John, on how I articulate law to students, Indigenous law, I often will, and this is part on, I should say that John is my PhD supervisor as well. The encouragement in John through that process is really using our language and the words and the concepts that flow out of them to describe, philosophize, theorize about Indigenous laws. And so that's what I kind of do. So just the small example is our word for law in Cree is Wiasawawina, which translates into the act of braiding. And so I start to think about that as like a theory of law. So you can think about, for example, behind me, there's this picture, and there's a story that goes along with that picture about this stone that landed in Nihiawaski in Plains Cree territory, and what that meant. And there might be a legal principle or a few of those in there. And we start to braid in our stories, experiences, and we can come up with what we would talk about in law school as a legal tradition. We can think about it as a philosophy, principle. And so I use my hair as an example because it's an apt one, because at the end, I have these terrible split ends. So it's even a better example that it's easy to break if it's on its own. But when we braid it together, we can pull it pretty hard. So I have a 2-year-old son, and he used to pull my hair, and it was easy for him to break it when it was loose. But when we braid our materials of law together, it makes it strong. And so that's an easy example, I think, for people to follow along. So it really does flow to that question that you have, John, about like, how do we put this into practice? Like, what's the worth of this braid if we're not having a situation that is pulling down on it, right? And so that's where I think when we start to think about that methods course, for example, is a really beautiful example of that we'll probably talk a little bit more. I think we're dancing around it a little bit here. But in my other classes is really giving a situation that we're going to actually apply this body of law to. So it can be in a number of ways. It can be the things that we see that are common when we think about Canadian law, for example, like a harm from one person to another, or it can be other examples of thinking about the future of a river and the river basin and the system, and how we're going to draft laws that protect that, or think of laws that will protect that as well. So then we can take those braids and then we can apply to that situation. The beautiful thing about that sort of work, it often dispels that kind of romanticism about Indigenous laws generally, and of, everybody is in agreement, because when you start to look at it, there are disagreements that we have in communities. You can start to use our traditions and our laws and our principles to really come up with decisions, what to do in those 2 specific examples that I kind of brought up here as well. And so I think one of the keys that I've learned, and like Naomi, I was past this methods course to teach that taught me a lot as well, is really to have that goal, to have something that you're working for. That is one thing that makes it, in the very limited time that we have in the law school curriculum, to work towards the end of a problem is to work towards that. And then for students who aren't used to that, then there's that kind of like, there's a really beautiful aha moment that most get to when they're like, oh, okay, I get this. I get, we're not teaching them the whole legal tradition, but they get the reasoning, the method. It's that those steps along that route.
Yeah, that's great. So Indigenous law doesn't just flow from agreement, although we do have that with one another. And it doesn't just flow because we're beautiful people and have a great big group hug. We're also messed up as people. We have our challenges and have had our challenges from time before time. And those disagreements require processes and principles to work through those as well. And so Indigenous law is both a product of agreement and disagreement. And to recognize that, as you say, Darcy, kind of dispels the romanticization that Indigenous law is just about some pure moment of utter consensus. In fact, many of our ancient stories, and certainly a lot of our contemporary experiences and stories, show that we have a big difference of opinion with one another. I often say that part of what we're seeking for as Indigenous peoples is not just the ability to be free, to be different from other Canadians when our land and language and rights are in place, but also to be free to be different from one another, and to have that respected as a part of our conversation. And that freedom to be different from one another in a orderly, peaceful, healthy way requires the kinds of things that you're talking about. And I've seen the application in specific cases when I've gone to potlatches, and people have named responsibility for a child that might be a sort of aging out of the provincial system, say at age 18, but they will stand that child up in the hall, and they will say, this is my child now in accordance with this law, and there'll be witnesses there. There could be dances and songs in relationship to that. Also in that potlatching structure, you can get territory, be recognized in a particular person or family, access to resources in that person or family. The law itself is often sung and danced, and it will be in relationship to who owns a crest, who owns a song, who owns an image. So there's intellectual and cultural property there. So like family law, property law, resource law, intellectual cultural property law. That's the Western labels for it. But within these potlatching systems, it really does come down to the particular case. And if there's a dispute about that case, again, there's witnesses that can come to bear. In other instances, it might be feasting in a feast hall or a circle setting, dealing with someone who's done harm. And it's not necessarily a criminal court, but you're saying, what are you going to do about what you did now? And how are you going to, deal with the graffiti you put all over the school? What's your responsibility for that? And how can your family help you through that responsibility? Or, it could be drafting constitutions. Or my daughter, Lindsay, who worked with the Indigenous Law Research Unit and then West Coast Environmental Law before that, worked with one community that when they put their constitution together, they put it out as a song. And so there's a specific case, a specific instance that people can access what their constitution is by relationship to that song. And so I'm hoping that you're seeing here that there's many different ways that these general principles that are diffuse can come down into specific instances by talking with one another, resolving our differences through principles, processes, standards, criteria, measures, etc. as a part of that. Now, as we think about this, Darcy, I want to ask you a particular question that came to us about pipe knowledge. I know that when you were doing your LLM, you talked about the sacred pipe. And the question here is, can you discuss your introspections and knowledge about questions of Anishinaabe laws, but perhaps for you Cree laws, how they are codified in the sacred pipe or how they're involved in the pipe? And if you maybe wanted to share a little bit as appropriate on that access there.
Yeah, for sure, John. And I appreciate this question. And so it's interesting when we think about our pipes, as Spwakwan, and what we talk about and pipe holding, because we do see that with a lot of, for example, my family and community, and then some other Plains Cree communities in the prairies here. We'll really look at this pipe as being, I like how the question is kind of framed as like, thinking of it as the codification of law. It's kind of like, I like to describe it as an institution, maybe, again, maybe borrowing something that doesn't quite fit, but it's a way that we center our sort of legal thinking and practices. And so this is an old, John used the word ancient, historic way of doing this. And with that, holding that pipe, for example, and having a ceremony, what is included in that is a lot of other legal teachings and pedagogies that are carried forward. And so there's the aspect of being a pipe holder. We have that sort of knowledge. So we have in my family a specific protocol, procedures, ways of being that go along with that, and a number of other Indigenous communities that have similar traditions have those. So that's the practice of that law. But then when we actually have the ceremonies, you can start to think about that. I like to think about it anyway, is a moment of centering of our legal practice in that moment. And it's calling forth, these lessons on law, the laws that we're doing there. And people are bringing their own experiences in those as well. And so I like to think about that, excuse me, in a way that we can think about, I know when we talk about it within my family about pipe ceremonies, they are highly contextual. So they are held for a number of different reasons. So one, it could be just for prayers for a family, for example. It can be a celebration. We also know that pipe ceremony was really important at, for example, the signing of our treaties. And so the laws of that, I tell this story about Wetaskiwin, which I just had the opportunity to tell people a couple of days ago as well. And the pipe was significant as like intersocietally between Nehiyaw peoples and Niitsitapi peoples, and in creating a treaty there as well, and that law. So there's this contextualization on our sort of pipe laws, and then, but it's also really contextual on the experience that they're having. And so the other thing I like to think about this is we actually have this, even if they're not using, using obviously, legal scholar language here, but this idea is actually something that gets deliberated upon in our communities as well. And so, for example, I know the Samson Cree Nation were working on codifying laws, and there's this. There was a little bit of discussion on a draft about how they talk about the pipe there, and it's really saying like, we understand like we are constituted by the pipe, but also we need to write down laws to, to walk, the language was to walk in these two worlds, to understand that there's an interaction with legal systems, and for people to understand, Plains Cree law in that respect as well. And so that tension between the practice and the sort of centering of ceremonies in the example that I'm using versus codifying laws, I'm writing them down on paper. That tension, it exists in our communities. And so I like to think about that. I often pose that to my students as well. I say, like, we do have people from our communities who will think about our pipe ceremonies as some sort of term of codification, and to start to interrogate that and to think about what that actually means is a really interesting question.
Yeah, in some instances with the pipe, it's like a seal that indicates that there's been an agreement or a covenant or something that's been concluded there. I also like to think about those pipe ceremonies as a space of silence that is allowing for reflection, for mindfulness and intentionality in the question that you're being posed. Pre-COVID and post-COVID times, it's about intermingling of our breath with one another, and we can actually watch that breath as it gets embodied through the smoke and it drifts around us, which is a message of the relationality that we share when we're working with the pipe. It's also, there are living dimensions of the pipe with the bowl as it gets attached to the stem, and there's so much to think about in terms of permissions then about using pieces of area, interacting with people that might be different from you. In that example of you having a treaty with another Indigenous group is quite powerful. So there's so much to say on that front, but it is also important to say, as you rightly noted, Darcy, that it's a big part of Aboriginal law too, because it's a part of our treaty history that we have with the Crown. Now, Naomi, we've been talking around this Indigenous methods course, and it would be great to just get maybe a bit of a sense of what that course is about. And some of the questions also were posing inquiries about the role of art in Indigenous law, or the visuals anyway, within Indigenous law. And another of those questions was about increasing a space for Indigenous ways of knowing in academic writing, like dreams and ancestral teachings, but also, thinking about that in regard to the course itself. So could you give us a little sense of that methodology course and how it might relate to some of these questions?
Sure. So the course that I teach and borrowed from my wonderful colleagues at the U of A and also taught at UVic, I would say it's sort of maybe perhaps two aspects to it. Or I think I would divide it between sort of a discussion of perhaps the why of Indigenous law and then the how of Indigenous law. So we spend quite a bit of time at the beginning, I think, around the why. We read your book, John, Canada's Indigenous Constitution, but I think what we, and other articles as well, but we spend time thinking about what law is. As we were discussing earlier, we look at some philosophy of law. We also look at the challenges around engaging with Indigenous law as part of this discussion. It also comes into the how, but the various challenges that can arise, questions around codification versus orality, various questions that people may have around legitimacy or accessibility of Indigenous laws. So we try to unpack that. In my class, we do a lot of exercises, sort of talking through sort of examples where this would actually be a practical reality, perhaps that you're going to community and you're talking with people. And so, and also talking about the challenges that community face in the project of revitalization, right? And the realities of that, and being a practitioner who will be trying to seek to engage and support communities in that work, and what are the realities that communities face, and how do we support them in doing, this work. So there's sort of that piece. And then there's the how, I guess I would call it, where it's about how does one engage with and revitalize Indigenous law, recognizing that, particularly because of colonialism, communities, laws may not be exactly intact necessarily. That there certainly are customs and traditions, and Darcy explanation about the pipe, and he's got a wonderful article about the use of the sweat lodge in Cree tradition, beautiful Creeness, which is a fantastic article. So although there are traditions that are there, there's also ways that that we have lost some things, but they're not gone. There are ways to revive them, and there are various sources, and I think that's what part of the question you were asking, John. And we've been giving various examples. There are various places that we can look to revitalize our law, including our language, including stories. Those are very significant. Art, our hieroglyphs, our petroglyphs, pipe ceremonies, traditions, the land, as you were describing, our deliberations with each other. So many ways and resources to draw on in order to draw out our law. So my second part of the class is talking about these and just highlighting a few of those. So we have a few specific classes. There's one where we just look at how our languages can be used to draw out legal principles and look at some examples that are happening now. We also spend quite a bit of time on stories and working with the story case briefing method in particular. We use that as our basis in looking at stories that teach us about how Mi'kmaq address harm, using that then to develop a legal framework that students will then do a moot from. And actually see the practical application. So I think that's what Darcy was sort of referring to earlier. But they see by the end, I hope by the end of the course, that not only is working with Indigenous law something we should and can be doing, but it's possible, and there's ways to work with and draw out laws from a variety of sources. Not that everyone's going to necessarily go to work with all of those sources, but to know that that's a possibility. And I do hope that certainly some of the students will go on to work with these methods and their communities in order to help those legal systems thrive.
That's wonderful. So you might know, as we've been talking here, that we've been addressing questions that have been posted in the question and answer box. And we really appreciate that because it's bringing a richness to our conversation. I would encourage you, if you have a question, to put it to us so that we can continue to work that through our conversation. It really is good to get that. So far we've talked about the joys and the challenges of doing this work. We've talked about some of the resources that are needed and the fit that we're hoping for. We're talking about what Indigenous law is as distinct from Aboriginal law. We're talking about some specificity about what the application of this law looks like in particular instances. And we're also able to, as Naomi just picked up there, describe some of the methodologies that we introduce to the students. We're going to take a 5-minute break here in a second and come back and pick up some of these pieces with our guest, Jeff Hewitt, who will also be a part of this conversation. So maybe talk about some of the land-based learning components that we involve ourselves with when we go out to communities and beyond the classroom walls, how we might work with one another across our different law schools and break down those silos and those barriers is another topic for conversation that we have. We also want to give more examples of Indigenous law so you get a sense of its concreteness as well as the work that we're doing. So I'll now just say, let's take a 5-minute break. We'll put our screens on quiet and at 1:35, we'll rejoin. And so we'll see you just in a few minutes. Thanks, everyone. like to welcome everyone back again. I was able to eat an apple. Nice to get a bit of a change of place here. Just so enjoying this conversation with Darcy and Naomi. We have Jeff, who's now joining us. I introduced him earlier as coming from Osgoode Hall Law School. Welcome, Jeff. Great to have you here with us. In a second, I'll turn some questions to you, but I just want to go through one point by sharing my screen for a moment before we continue, which is to talk about just briefly some of the sources of law that are concrete. So there's these wampum belts that Indigenous peoples signed with the Crown to help set up our country in certain parts of the world. The two-row wampum, the dish with one spoon between Haudenosaunee and Anishinaabe people, the covenant chain, which is illustrated here by the linking arms together. You know, in 1764, there was an agreement that brought people together over 2 months and passed 84 wampum belts in that area. And they still help us do our work today in sorting out what our relationships are with one another. There are these environmental assessment processes like this one with the Skichison and Tecumloops who have pulled together their families across Indian Act communities to address issues like health and indigenomics and sky world, fauna, flora, fisheries and water world, using their stories and language and principles and process and standards and criteria to decide whether or not to bring or allow a development to occur in their territory. And that's that counseling together process. And of course, scientists are involved in this as well. We've got the Niska example where they've taken a Westminster form of government and they've modified it to make it consistent with the House, not consistent with, but make it work in relationship to the House systems, their WILP systems. They've modified Robert's Rules of Order to make it Niska, but they also have their parallel process as Niska people. We've got things like the West Bank First Nation who have a particular self-government agreement or legislation actually that the federal government recognizes their ability to work in these different spheres. I mentioned Anishinaabe constitutionalism, where we're writing down these things that reference our 7 grandmother and grandfather teachings here that you can see referenced in this area in the work. This Bill C-92, an act respecting First Nations, Inuit and Métis children, youth and families, is recognizing the inherent rights of Indigenous peoples to make their own laws in accordance with their own authority. And this is federal legislation that recognizes that inherent power and gives Indigenous peoples paramountcy in relationship to other federal laws and also paramountcy in relationship to provincial laws in instances. There are these Indigenous courts that can happen throughout the land. Of course, we all know about issues of Aboriginal title that are a part of our lives and land protection. That is, there's so many sources of these laws to look to that are very concrete and very much a part of our day-to-day practice. And you hopefully can see the relevance of Indigenous law in those different categories. Jeff, before you joined us, we were talking about some of the joys that we have as teaching Indigenous law, some of the challenges that we find in doing that. We talked about what Indigenous law is as distinct from Aboriginal law. We talked about some of the need for resources and support and fit. We also talked a little bit about the Indigenous methodologies courses that we're a part of. I wondered if you could share for us your joys in working in this field, as well as some of the challenges, as kind of a lead-in to talking about what schools can do across the country to start to break down the silos that might be there between us. So joys, challenges, and then what we might do to start to join together in more effective ways.
So Tansei and Dukdamuk, hello everybody. I'm sorry I'm late. I was actually teaching some of the very subject matter that we're talking about this aft. Joys, I think the singular one for me is I actually get to stand in front of people and engage in discussions about ways of being and thinking that I love talking about. It's always a richer discussion, I find, than just when we look to doctrine and summarize, which isn't to say that isn't helpful and useful. It's just, it's for other people. I think to find joy in where I don't always, but a necessity. And and so I love actually engaging with the ideas and also the conversations with students and colleagues. I think also same thing for some of the challenges. At Osgoode, we have a range of courses, and there's a certain number of credits that students are required to obtain before graduation in either Aboriginal land or Indigenous legal orders, which not the same thing, as I know you've talked about. And so one of our big lecture courses that I've taught for the past couple of years is Indigenous people and Canadian law. And I think one of the challenges that arrives, or that maybe I manufacture, is that if it feels compulsory as opposed to a want to be there, then there can be maybe resistance, I anticipate, to materials and to discussions. And indeed, in some of the feedback from students when they're doing their evaluations, that comes up with a few of them. But I also think, and so I think it can be a challenge to try to sort through ways in which we teach this to students in a room who want to be there and some who really don't want to be there. The way I tend to put that to students up front is to say, look, I didn't really want to be in torts either in first year, but I had to be there. So I was there. And what I didn't do was make torts miserable for everybody else. Though tempting as that might have been in a few moments. So this is part of a legal education, and here you are. So how about you engage with this? And I do that proactively as a way of kind of joking about it up front, just to find space to respond to potential challenges. I'm probably talking too long about that. And then you asked me about something else that I'm already forgetting because I found gray hair in my eyebrow, indicating I'm now getting old. So there's that.
It's partly about breaking down the silos between law schools, but I think we should stay with what you're saying for a second. You know, there are these calls to action from the Truth and Reconciliation Commission that were particularly directed to law schools. I'll just read the 27th call to action, actually 28th. We call upon law schools in Canada to require all law students to take a course in Aboriginal law and the law, which includes the history and legacy of residential schools, the United Nations Declaration on the Rights of Indigenous Peoples, treaties and Aboriginal rights, Indigenous law, and Crown Aboriginal relations. This will require skills-based training in intercultural competency, conflict resolution, human rights, and anti-racism. As you hear that list there, Jeff, and that call, where does your mind go to in terms of the possibilities for us?
Well, one of the other things that I've been doing, and I have to really credit Brenda Gunn for getting me thinking this way, is that at the beginning of every course where I know I'm going to be teaching Indigenous laws, like IPCL, for example, I actually hand out recipe cards at the very beginning. I didn't do it this year for obvious reasons, because I didn't mail them to, but I hand them out. And what I say to the students is, we're about to embark on this together, and some days are going to be good, and some of it's just going to be hard, and some of it's going to make us happy, and other parts are just going to make us miserable. So here's the thing. We actually can't talk about any of the work TRC is asking us to do unless we can have some more honest conversations about what we're thinking. So what I ask all of the students to do is to write down one thing that they would like to know either about Indigenous peoples or laws or whatever. And I say expressly, even if you think it is racist, write it down. Do not put your name on this. Because what I do then is spend about 10 minutes at the beginning of every class after randomly picking out the numbers, the questions. And we just go for 10 minutes and then we're done. Sometimes I can answer the questions, sometimes I can't answer the questions, but say I will find it and bring it back. And then at other times I try to find ways to lighten the response to the questions. But when I talk about that, I say it in the context of two things. The first is we have to ask the questions and have the conversations. And the second, if we can't do that honestly, then we're really not going to get anywhere except manufacturing something that we think we're achieving. And And the second is, from a pedagogical perspective, it actually gives me a sense of where the class is at. So if there's a class set of questions that are fairly sophisticated around certain cases or news stories, for example, that's one thing. If it's a set of questions that are pretty basic, then that's how I can gear how I teach to the class. We never get through them all, we get through some. But that's one of the ways that I try to address the hefty lifting TRC set out for law schools. And the other thing I explain is that for the way Cree law has been taught to me, or is being taught to me, is that it's fundamentally about being a good relative. And so asking questions and working together in these ways that are starting with honesty, albeit anonymity, is part of how we practice being a good relative. The other thing I tell the students is, in that practice, when I read your question out, do not like high five your neighbor to signal that that's your question. When a question comes up that you don't like the terminology to, in spite of my invitation to say write it even if it's racist, do not start looking around that classroom with the look on your face like, who did it? Who did it? Who asked that question? Because it's about us sorting through our stuff, and that means sometimes some harder work. So regardless of what the subject matter is week to week, I usually spend a few minutes trying to do that to get the conversations going with students.
Yeah, that really sounds like the necessity of creating a space of trust with the class where there is a vulnerability that's present that isn't about a gotcha or sort of calling out, but trying to understand that we all have things we need to learn. And it's wonderful to hear that that's what we're called to do by that call to action, is to be teachers and learners together. Now, another question that we kind of approached the last time we were together, just before you came on, was this question of Indigenous art as it relates to law. There's one question I'm going to read to you here, which maybe you can reflect on, because I know you've done some work with art and law. And if you have things to say about song as well, or story, that would be welcome. This might also shade to outdoor learning. But here's the question. I'm interested in Indigenous art as a form of Indigenous legal documentation. Perhaps Professor Hewitt might be able to share more about his analysis of this. And the person who writes the question says, I'm doing my law master's on the legal literacy of Maori visual art at Otago University, specifically on carving, moko, which is tattoo, weaving as law. And so I don't know if you have reflections on that, but it's just another way of trying to express and understand what law is by being attentive to the art dimensions, which might not always be imparted in lecture format or statutory format.
And so let me just say off the top to the person who posed the question, I'm around if you want to talk at some point, and I really look forward to reading your work when it's done, because that's a beautiful way to be engaging in law. And in terms of sort of quicker reflections on that, I do a lot of thinking and try to do work around expanding what we mean by law. If we think about it as the rules of how we engage with each other, then why does it have to be written in French or English to have validity to it? Particularly from Indigenous nations that didn't speak either one of those languages as laws were being formed and developed over millennia. And so the point that I've tried to make in other spaces around this is to say, listen, just because you're looking at what looks like a painting doesn't mean there isn't law that's embedded in that. It just means that we might be illiterate in being able to read the painting. In the same ways that, you know, English and French are curves and lines that just form letters and words. And as we string letters together and they form words, I know that a curve and a circle with a line and a little sticks form cat. But a CAT doesn't really mean anything on its own until we put it together. And then I'm importing the meaning that I'm told those curves and lines mean, right? Because I'm learning the literacy of how to read and understand English and imply meaning, which is abstract. Same with art, right? If just because some indigenous nations embedded teachings in rock paintings and in songs that were sung over millennia and transferred down doesn't mean that it isn't law. It just means that we might be illiterate in seeing that. In the same way, if I couldn't read French or English, it doesn't mean that there's no such thing as common law. It just means I'm illiterate in that. And so I would say it's important that we actually turn to indigenous methodologies and sources of where we placed law. So in land and in songs and in dances, also in regalia. And I want to just for a second not miss the fact that what we might in English describe as material culture, so things like regalia, ribbon shirts, moccasins, and beading pieces, the things that often get described as I think improperly women's work, doesn't mean that it also isn't art and doesn't have teachings of law on how to be good embedded in it. It just means we've described it in another way of being material culture. But there's I think a lot to talk about with respect to how we can source law. I should also say, all art produced by an indigenous artist does not necessarily mean it's also got laws embedded in it. Sometimes it does, sometimes it doesn't, but that's also a question of literacy. How do we know something is a work of fiction and something is nonfiction or autobiographical, right? There's within a bigger world of books, there are categories. And so I don't also want us thinking that just because an indigenous artist has painted or sculpted something means that they've also placed law inside of there. That's more to literacy, if that helps at all.
Thanks, Jeff. That's excellent. We put you to work here the last 20 minutes and really appreciate
Really
you.
has. Yeah, I'm going to sign off now.
Just want to make sure that you're feeling loved. I want to take these questions and pass them along to Naomi and Darcy. In particular, that one now about siloing, that we don't want to just have everything occur from UVic or Osgoode or Dalhousie or U of A, that maybe there's like 20 some odd Indigenous professors in Canada, and there's just such a need, and we don't want to be in competition with one another. We want to find ways to support one another, because then that's about supporting the communities, that's about supporting the students. And Naomi, I wonder if you have some thoughts around things we could do nationally and internationally to pick up this question of ensuring that we just don't get stuck in our tracks within our particular institutions.
Absolutely. And just sort of reflecting on, I think, how, engaging to date as a colleague with other Indigenous scholars, it does seem to be that we are very much about sharing with each other and supporting each other. And that's been wonderful as a younger scholar. And I don't know, the other day somebody said something like, something about Mi'kmaq. I noticed they were not Mi'kmaq, but you guys like meetings, you like big meetings, and you like to include everybody. And I was like, yeah, that's how we roll, that you have to include everybody. But I also think that really should guide how we move forward. And I mean, logistically or practically, as you're saying, John, at this point in time, there isn't enough of us to do such wonderful needed work. And we're just talking about it within our institutions, but we all know we get pulled to do more for the community, and that's where a lot of our our hearts are, where we want to see this work happening. But you want to be sort of training the people who can then go do that work. But we're a small lot yet. So from a practical perspective, but I also think from a principled sort of perspective on it, it will be so much richer if we have this collaboration. I wouldn't be doing what I'm doing at Dal, and I think right now it's just a little drop in a bucket of what can be done, but without the kindness and support of colleagues like Hadley, who just shared everything. And now it's with me with what she's done, and it's sort of become this nice reciprocal thing that I'm taking. Sometimes I do slightly different things in the course, but I share that stuff with her and she's adapting it. So it's this beautiful synergy of us working on the different things in different regions, but building on our shared knowledge. And so I would love to see that ideas of a network that can support each other. I don't want to take up all the ideas. I'll just throw out a couple, and maybe we'll riff on more. But I think that we can help and support each other in terms of our teaching and collaborating on curriculum and materials. I would also maybe like to see this idea that, you know, our students can take each other's courses, right? And not simply be bound to only taking that one Indigenous law course that Dal currently offers, for example. Other ideas that I'll stop at before allowing other people to throw in. I've got wonderful library staff at Dalhousie, and they are keen and they want to do work in this area. Some actually just sat in on the methods course or aspects of it to learn. But I think there's a real role that perhaps our institutions can play in helping collect these, you know, resources or identify them and to actually recognize them as legal resources, collections of stories and making them available, collections of interviews. There's a woman who works at the university who is a Mi'kmaq filmmaker who's got hours and hours of footage where she's interviewed Mi'kmaq elders and knowledge holders. And it would be wonderful if she could share that work. Right now it's sort of wrapped up in some copyright stuff, but there are all of these resources that I think it's important. It would be important to start gathering that and actually having our institutions, librarians support each other in that work and do that work and work towards having more Indigenous librarians as well. But I think that would be a really interesting collaboration and between our institutions.
Thank you. Now I'm going to give it to Darcy in a second, but I just want to pose this question as we work into the answer that Darcy will give us. It's a question that says, I would appreciate hearing from the professors about who gets to learn our Indigenous laws. We know that Onkwehonwe, Indigenous peoples, continue to be underrepresented in post-secondary institutions and law schools. This means that the majority of students who are learning in these institutions are not Indigenous. While I have and hopefully will continue to live and learn about my Indigenous legal systems for the rest of my life, I'm always curious to hear more about who is able to learn in these other spaces and what the pros and cons are about sharing our laws in this way. And so this is a question not just about siloing across universities and trying to find ways that we can join with one another across universities, but what are our kind of responsibilities back to the community, back to people who will never come into law school, never be a part of sort of the formal degree elements, but nevertheless can be with us and we can be with them and also recognize there's things we can't do and shouldn't do because of you know, the particularities of those laws that shouldn't be shared in certain contexts and times and places. So I know I've added a lot to the question here, Darcy, and you can pick up whatever piece you want, but it's about sort of trying to see the way that these things flow together.
Yeah, I missed part of that because I just realized I had gray hairs as well. So Jeffrey's got me a little self-conscious here. They start there and then they just start slowly. Yeah, so this is a wonderful question. I did see this in the chat as well. And so Naomi did steal a lot of my ideas. But the one thing I was also thinking about is, I often think about, now I'm just getting off topic here. I often think about the movie Back to the Future, and there Marty McFly is on the stage playing rock guitar that's come from the future, obviously. And then you don't get this, but your parents will, that kind of, or your children will. I kind of feel like John and Val were kind of like doing that work for us in this field of like, you're going to get this and there's going to be a wave. And I feel very lucky, even just in terms of like our community. So the first time I met Naomi, I think she told me, why don't you just start applying for jobs to teach? Within about 10 minutes of talking, those sorts of things. And Jeff, before I met him, he was really supportive before we actually saw each other in person as well. So there's this supportive community, but I also think that there is a wave of the work that people have been doing that is going to, I almost think of it as like this harvest that's going to happen. And I think on top of all the great things that Naomi was talking about is really thinking about being forward thinking towards that. So, because we're going to have more communities represented when we think about Indigenous laws in academia, more theories, more problems to work through, more intellectual debates. So thinking about, you know, universities thinking about hiring people who are doing this work with Indigenous legal orders. And then there's quite honestly, there's just like a resourcing thing, right? That I think that universities, you don't want to be on the sidelines as we continue to grow here. And so I think pushing how we can support each other across universities in terms of that, because I do know, even with the calls to action that you brought up here, John, about 28, I know for our institution, we've committed to that, but also we know that that work is a long ways in coming. And then we start to look around at other schools and what they're doing as well. There's this kind of feeling like, oh yeah, we got to get on this. We got to keep on this as well. And so that kind of network of support and understanding where we're all kind of growing together, I think is really important. So tied into your second question there, John, about who does this learning, I think there is there's two ways. I do kind of share that concern about the underrepresentation of people from Indigenous communities in these programs. And so I think that is a large one. I think we have to continue to be really cognizant of that. And again, that kind of goes back to the structures of faculties and how they're making that movement. So kind of that thing I said, like the tide needs to change in those respects. And I know there's a lot of great work that's going on in faculties about that as well. And then the second one is, I've started to find, even like I had this natural feeling, quite honestly, even thinking about like talking about Plains Cree law in law schools and what people would do with that. Would they misinterpret it? Would they finish a class and then go think they're an expert in this? Those kind of like feelings. And really there's a really natural accountability process even within these teachings. So I really appreciate what Jeffrey is talking about with just setting up a class in a good way to have that accountability with each other, but also a safe space to learn. And I often talk about, for example, people get concerned with stories and misinterpretation of them. And I say, well, the first thing is you're not going to break the story if we have a dialogue on an interpretation here. There's still a tradition of the story being told in communities that's different as well. And then two, if you're actually asked to apply, like the work, for example, that the Indigenous Law Research Unit does at the University of Victoria, there's a community there that's guiding you, that is informing the process, is directing it, is criticizing, is giving all those learnings as well. So there's a built-in natural feeling there as well. So when I share the concern of the question, but also know that as we think about this new way of thinking of Indigenous laws and faculties, we're also developing those sort of methods of accountability and also just making it the most viable educational experience for law students there. So I had another joke, but I'm going to park it there and I'll turn it back to John.
You know, another thing this causes me to think about, and it's related to another question, what is the benefit to non-Indigenous peoples learning about these laws? It's related to that question about, so who gets to learn these laws? You know, when my great-great-grandpa entered into a treaty dealing with 1.5 million acres of land in Ontario, put his little otter totem on the treaty, he invited people to come and live in our territory in accordance with our laws. And if people don't know what our laws are, they can't live in accordance with them. And part of that understanding in the treaty was, like I started out with, appreciating the bears and the seasonal changes and the way that law is learned from our relatives or what exists around us in the natural world, that then we add to language and song and art and deliberation, etc. So I think there's a great need for non-Indigenous peoples to learn Indigenous laws so that they can start to comport themselves in accordance with that law, which is designed to respect and understand that we are the last and the least of those relations that we come into with the water and sky and birds and insects and plants and animals, and that if that can be imparted to some small degree, then people might start to see this as a part of the law of the land, a part of maybe their responsibilities for thinking about how reconciliation with one another as humans is really contingent on or dependent upon our reconciliation with the earth and the water. And so I really think there's a degree of that aspect, which is the breaking down of silos and seeing that, yes, there are some laws that we have as Indigenous peoples that we only expect will apply to us if we're in a potlatch structure in relationship to land and witnessing, but there are other laws where people can be invited into those. And certainly, in my understanding of many of the treaties, that was a part of it. And so the questions are great because they help us think through these ideas. Another question that keeps coming up is permissions and copyright, and when might you overstep your bounds of something that's not permissible because you don't have that say so from someone that you've been working with, or you do have that, but it's hard to be able to verify or reflect to others. Some of the things we talked about before gathering here were developing national courses that might address some of these questions, or law journals where we can put these methodologies together so that people can join on these questions. Or we're thinking about supporting Indigenous students, as Naomi said, to get involved with one another in our courses in our particular schools. So I'm not sure if you have further reflections on those questions of national courses, law journals, partnerships across schools, and as it relates to thinking about the permission element and not making sure we don't overstep ourselves, right? We need to be very careful not to take anything that's not ours, right? The law keepers are out there, the elders are out there, they're not necessarily in the schools, and we're so small anyway, even if there was one or two of us in these places. So thoughts about that, Jeff? Maybe go to you first.
I feel like in the same ways that other scholars, the non-Indigenous scholars that we bring into courses we teach are out there and not in the class, we still bring them in, and there's a peer review process that brings us the publications that we can then rely on to put on our syllabi and bring those voices into our classrooms. There are also processes by which all of us are deeply engaged in order to have the same kind of review process before we're able to go in and say pretty much anything. Also, the way Darcy was raising it too, the nervousness, I think, well, certainly I have too, around what can I say, what can't I say? And I start it usually with citations, right? So I say, look, I'm about to tell you this, and this is where I learned it, and this is who taught it to me, and this is the space that they're from, right? Because I'm also teaching in Anishinaabe territory, so I cite Anishinaabe people who have taught me the laws of the lands that the law school is in and we're learning. And so I think there's ways in which we, I don't know, formalize or semi-formalize the I think authorization is the wrong word, but the okay to kind of bring things in. I think the other thing that we all have going for us is the second we're out of line, there's just a whole bunch of people that are going to tell us exactly that, often before you get the second word out of your mouth, right? It's like a no. And when I'm particularly when I'm setting out on something that's a new area for me, I will typically actually bring people, if I can, with me into a room. So I've had elders come into lectures with me, and I have said to students, so here's our guest today, and here's who they are, and I want to be clear about a few things. They are here to check me. I am going to say some things. And you may not hear them checking me because it might be a quiet conversation at the break or after the class, or you may hear them publicly interrupt me and correct me on something. And I want you to know that that's actually part of the process that is a good thing for me, not something you need to be worried about for me or them, but it's a process that is happening constantly around understanding and engagement and accountability. So I would say that piece. On the, just reflecting back on the who gets to learn question, which I love because that also is a source of consternation. Few things that have happened at at Osgoode is when we do law camps, we do some in Rama, and when we do, it's always fun for me to try to explain to school administrators that the budget needs to be a little more open-ended because we don't know how many people we're going to be feeding. And when the administrator says, oh, but you're taking 30 students, so 30 plus the faculty is 34. And I say, right, so could be actually 134 because we open it up to everybody in the community, right? Because you don't go to teach in spaces that are other people's spaces where those laws have been sourced on that land and then exclude them from also not being able to engage in those spaces. And sometimes it is 130 and sometimes it is 30. So there's also those ways of accessibility. But then a national course that you were just talking about, John, too, I think one of the things that we've all become Zoom efficient at has helped us also now find ways to come together for national course or courses, right? So it could be a survey course where a number of us just teach for a couple of weeks on our particular areas. And then we get to listen to everyone else along with everyone else. The students can be at all of the law schools, but also in communities as well. There's no reason why that can't be opened for community accessibility for free. Because I do not get to teach without community people who are not formally in the law schools being able to tell me what I need to know to go and do that work. So I'll leave it there.
When I do my land-based courses back at home on the reserve at Cape Coqueror, it is that process of trying to create a space where people can come and go in the community as they feel comfortable. And that's a little risky on a professor's part because you never quite know what's going to happen, but it's always instructional. It always leads to teaching opportunities. And to realize that you're not the center of attention, you're not the expert in that space, you are the facilitator, you are gesturing towards and pointing towards other places, people, plants, birds, animals, structures, representations, is an important part of the work. And that causes a certain level of discomfort because it's quite right that I will be called out in some things that aren't being done in accordance with what's expected by the community. We had one instance where we do these also in other communities. We went down to the Chippewa of the Thames with Western law students. And in my territory, my elder, Basil Johnson, taught me that we should be using our trickster stories in all seasons because they're needed so strongly at this moment. But we went into that territory, which is just about 3 hours away, and they don't talk about the trickster when the snow is gone and the frogs start to croak. And I was giving a story and the frog started to croak. I kept on with the story and we had a really amazing moment, actually quite a long series of engagements around what does this mean. And so the students got to see law in action and they got to see what it's like to be corrected in a way that allows you to do the work that's necessary in that context. Not assume just because you're Ojibwe from 3 hours away, you know what would be necessary to do in that particular setting. So I really appreciate what you're saying, Jeff, about having checks and balances and having oversight or accountability or transparency. And one of the questions that's in the chat function has to do with Canley and Westlaw and all of these kinds of places where we might be able to get communication of some of these issues. UVic has hired Ry Moran, who is a librarian and archivist, and he'll be co-chairing the next session that we're hosting here with these national next conversations. And some of the questions around copyright and scholarship will definitely be shared in that context. But I want to take us back to that land-based point for a second, which Jeffrey was talking about at the Chippewa of the Rama and what I was talking about in my communities. Darcy, you did a PhD based on land-based learning and what we can understand. How do you envision helping students, not just at the University of Alberta, but maybe thinking about this as helping one another? How do you envision doing land-based learning that becomes a more significant part of legal education?
Yeah, that's a great question. And so there's two ways to this. I mean, one is that model of taking students out into the land and then, for lack of a better word, intensive period that you've both talked about, and um, teachings, gatherings. There can be a number of different reasons for this. And the way I've envisioned the work at, for example, I'm at the University of Alberta, is tied into the course material that I was doing. So I haven't been able to do this because of COVID and restrictions, but I envisioned the first 3 weeks, for example, of my course, which I'm teaching now, would be going out to sites where we have that are significant for treaty. So I mentioned Wetaskiwin is actually the name means living on the land together, and it's a site of treaty. There's these hills where I grew up. And then there's another area a couple hours away that is called Ribstone Hill, and it has these buffalo stones that have been carved into the ribs of buffalo, and there's tons of our prayer flags, and it's a significant spot that's been again a treaty spot for Plains Cree and Blackfoot peoples. And so in my research, I actually went out there, just drove out there to spend some time on the land, and it's just what I'm reminded of it was just in that experience, this sensuality of getting into land-based learning is the way I can talk about it, is that we lose our grasp on these types of big case books, and we start to grasp like the areas around us. So I do an Indigenous environmental law class, and we'd walk in the river valley, which is right near the university. And we did it once during the fall, and we were looking at choke cherries and talking about, I'd share what that kind of meant in our ceremonies. We have the river, which is really close by, and I would share a story about that. My brother lives in an apartment across the river, so I got to tell a story that he told me when I was 8. And as contextual as that is, I just found it so important in terms of like just the building blocks of understanding what we mean when we think about land-based learning, and so my reflection on that, if I can cap it, is really, it's like everything, it's just a snippet when we're doing this land-based learning. But it's going into more of that sort of process and method, and not necessarily about the content of what we're teaching there. So I really appreciate you talking about that teaching moment, John, about talking about the trickster in the snow and how that is revealed there, because that's actually what I've been learning about this land-based model as well. It's really about that process, and then there's just the learning goes there. So I know that frustrates people from a Western legal mind, because like, we want concreteness and what was our lesson plan right now, but it's just like being comfortable with that sort of like sensualization of legal learning, and then starting to think about what that means.
This is what you're saying in part, is that this learning is experiential, right? And in order to get the sense of what's off and on limits, as Jeff was describing in some of his earlier comments, you have to be there, and you have to figure out how the fiction is different from the nonfiction, or how that river might be different from the choke cherry, and know where law is there and where it's just a pleasant aesthetic experience, right? And that is part of what you're taught in that instance. I'm just looking at an article here from the Montreal CTV News that just came out this morning. In Canadian First, Quebec Whitewater River declared legal person with its own rights. The famous Whitewater River in northern Quebec is the first place in Canada to be declared a legal person, legally speaking, under a new environmental strategy that's taken off in some other countries. Now I'm seeing here that the Innu people are a part of the work that's doing this. So people close to the river will be those that are watching over it for now. And it's that treating parts of nature, plants, and animals is the idea of understanding this way of working. At the University of Victoria, we have a joint degree, common law and civil law. Common law and Indigenous law, and we teach transsystemically in the classroom in the first couple of years. So I teach an Anishinaabe constitutionalism course at the same time I'm teaching about Canadian constitutionalism, and my colleague does Cree law and criminal law, and then someone does Gitxsan land and property law, and Hulkaminam law and tort law, and Silcotin law and contract law. But then in the upper years, there's 2 semesters of 4 months each where students do field schools, land-based education, learning from people in the community, and then working on projects that integrate both Indigenous law and Canadian law into trying to answer those questions. It's another model of thinking through field schools. And I'm hoping that can be something that develops across the country, that there would be something in many places where people could be introduced to what their obligations might be in those places in accordance with what Indigenous peoples have as the respect that's necessary for that place. Right now we do territorial acknowledgements, right? Very important, very good. But where's the experiential development of that? Where is the standards, principles, authority, criteria, measures, signposts, guideposts? So when you go out into those places, that becomes a part of our law that we live in relationship to. So it's really a fantastic thing to be in this session to think through these questions. And there's so many that are posed here in the questions. I want to pose this one. I'm a Métis prof who teaches at McGill Law, and I'm a bit of a citations nerd. This is Carrie Sloan saying, I've been doing some work with the McGill Style Guide, and we're working on creating a culturally appropriate process for making changes to the guide to incorporate Indigenous law. We hope to work with elders and community and also talk to scholars and practitioners who use the guide. So please stay tuned. I would love to discuss, for instance, how to appropriately cite things, but also what shouldn't be cited, how not to pan-indigenize, and what's beyond the purview of the guide. Perhaps a discussion for the next session. And thanks for what we're doing here. I just read an article last week from an Anishinaabe scholar who I think is doing her PhD at Trent, who talked about citation of dreams and 6 different ways of citing those dreams. I wrote a whole book called Drawing Out Law, A Spirit's Guide, which flows from dreams. So do you have any thoughts about what Carrie is asking here around the practices of citation when we're talking to our students? How do we help them see that it's not us, that they can look through us to see the other things that are going on that really give us this place on which we stand? Naomi, do you have any thoughts about that, or Jeff? Naomi, go ahead. Okay, Jeff.
Oh no, I was actually relieved that Naomi got the question, so I'm gonna maybe leave that with Naomi. Oh, your name came first. Your name came first. I thank you also, Carrie, for the question, and I really like how you often provide the softball questions, because it's always helpful when you're actually the one on video. Yes, I do, and no, I don't. I think we all struggle through, let me not say it that way. I struggle through times when, how do I cite something, and do I, and or should I, and the ways in which that happens. When I don't know, and I actually just was talking to somebody about this recently, I tend to ask, and ask around, and ask also different people, to get a sense of, like, do I cite this and how do I do that? And I do not mean, by the way, I don't go to my law school colleagues who I adore to ask about these things. I actually go to different Indigenous people and start asking about that, who don't have that formal Western legal training around citations, but understand relationships. And so I think in many ways we're talking about the citations of our relations, and how do we do that? And you were talking a bit about that earlier, John, and Darcy was too, when he's talking about land, right? Those buffalo are relations, and so are the stones. And so how do we cite them when they're teaching us something? Because they are. And I don't know the answers of the formal process of doing that. And what I have been tending to do is just write what I think is okay in terms of a citation, and then ask about it. But I think to Carrie's also more finer point there, what should be cited and then what shouldn't be, I think does 2 things. One, I'm not sure we should be looking for a hard line on that, because I think it will change over time. as we are drawing in Indigenous laws and the influences of that work of those laws is being done, I think we'll see a different conversation we're having in 2031 than we are in 2021 on citations, and also what should and shouldn't be, because more might be poured in. So I'd like to see us being able to cite things like the color of beads and the place of stones, and the ways in which they mean something to our work and our thinking that we're writing about. There's also some challenges, I think, in shifting from dream world, which you did in your drawing out law, where you engaged in more than one way of citation, right? There were pictures that were citations, and then there were the more formal footnoting and endnoting, etc. But part of this is a requirement of the system to also change. And the ways in which citations, just because they've been done in writing for a long time, doesn't mean that that's right for all things. Those citation methods were developed for Western methods of engaging with knowledge in Western knowledge systems. And they work because they were developed for those knowledge systems. But when you are talking about different Indigenous nations and therefore talking about different knowledge systems, the ways in which knowledge is organized and constructed, there is something there about requiring a different kind of citation that fits within the knowledge system within which it was generated. And so we have to look to places like maybe McGill Guide doing some of the lifting, but not all of it, because there will be spaces that fit into the knowledge system that the guide is trying to sort out. And also there's going to be forms of knowledge that just don't fit in. And so we may have to be thinking about ways in which we cite, and there are practices, right, of how we cite knowledge already. Question becomes, what is that going to look like when we're moving from oral to writing, or from dreaming to writing?
It's a great wrap up in thinking about what our work is in terms of the information that's not familiar to Western literacy in terms of citation, but we need to be a part of making those changes. I want to acknowledge that the questions in that have come to us have been really great food for thought and discussion for us. And there's some questions that relate to UNDRIP, United Nations Declaration on the Rights of Indigenous Peoples. There's some questions that relate to learning from other Indigenous peoples and other Indigenous laws. Our fourth session in this National Next Conversation series will be about the international realm of this and the comparative realm. So I hope you join us for that. Some of these other questions have been about the relationship of Canadian law to Indigenous law, and we haven't really dwelt on that too much either. We've kept our focus fairly squarely on Indigenous peoples' revitalization, the resurgence of Indigenous law, but that's a huge and important question as to how our laws then would relate to Canadian law, and we have an opportunity to pick that up as well in the next second and third sessions. So we hope you would join us again. It's coming time now, and it's just left for me to express my appreciation to everyone who's gathered with us over these past couple of hours and shared this space and been generous with us in walking through these thoughts. I also want to thank Jeff and Darcy and Naomi for their amazing contributions to this work. I want to really express my appreciation for Castlemaine in helping us coordinate this session and the other ones. It's been really delightful to work with them. My colleagues across the university have made such a huge difference in this as well. We will be convening next on March the 8th, and we'll be focusing on building partnerships between Indigenous communities and Indigenous legal research. So at that session, they'll be sharing of best practices for developing respectful and meaningful relationships with Indigenous peoples in their work. We'll also hear from a couple of communities who have brought their own laws forward in consultation and research and working through the legal processes. So you can find this on our online hub. We invite you to register and get more information there as a part of your participation. Our event team is sharing a link here, I think, as we're moving along. We also invite you to continue the conversation online at the hub, where a recording of this session will soon be posted for people to view with a corresponding discussion forum to continue sharing ideas and generating conversation with one another. Right? This is an ongoing thing. This is the next one, but there'll be the next and the next and the next one. And you'll also find a survey here to be able to share your thoughts with us. My warmth goes out to you, my love, my hopes for you. I hope you're safe and well, and that you're able to find what you need from what we've talked about, and that you will feel and hear the invitation from all of us to work together on this. And with that, I'll say Bama Pi Gigawabman, Miigwech Biajayan, and take care. See you later.